Hi, everyone, and thank you for joining us today. I am Allison Walsh. I'm a partner in Dentons Employment and Labor Group, and I'm also the co-chair of Dentons Canada Workplace Investigation Practice Group. In addition, I'm also the host of Dentons Canada Employment and Labor podcast. A link to our podcast series will be in the chat function if you're interested in listening to that podcast, which includes a three-part series which discusses workplace investigations that goes from conducting an investigation all the way to preparing an investigation report. Today, I am joined by three presenters: Roxana Janke, who is a senior associate in our Calgary office, Victoria Merritt, who is an associate in our Vancouver office, and David Conkin, who is a senior associate in our Calgary office. In today's webinar, we will be covering why and when to investigate, key issues to consider when investigating, and also the consequences of a flawed investigation. Our first presenter today is Roxana Janke. Roxana is a member of Dentons Employment and Labor Group. Her practice focuses on the management side of employment and labor matters, including advising employers on workplace investigations. Today, Roxana will be discussing the issues of when and why to investigate.
Thank you, Allison. Good morning or good afternoon, everyone, depending on where you are. As Allison mentioned, my name is Roxana Janke, and I am a senior associate in the Dentons Employment and Labor Group in Calgary. In the next several minutes, I will be discussing when an employer should be conducting an investigation, as well as why it is important that investigations be completed. So to address the why first, investigations are important in both the unionized and the non-unionized workspace, because failing to investigate or failing to investigate properly could potentially result in significant risk and liability on employers on various fronts. One of the most obvious instances where there is significant risk and where an investigation becomes extremely important are in situations where an employer may decide to proceed with terminating an employee for just cause for serious misconduct. As we all know, in these situations, employees can bring a wrongful dismissal action, or in the unionized context, a grievance challenging the employer's decision to terminate. Now, during a trial or a grievance hearing involving discipline or discharge, the employer has the onus to prove that they had just cause on a civil standard of a balance of probabilities, that they had just cause to terminate the employee. Also, it's important to note that courts, arbitrators, and tribunals also recognize that allegations of serious misconduct may have significant impacts on an employee, and therefore they have pointed out in various decisions that an employee has a right to hear and respond to allegations against them before an employer takes any disciplinary or remedial action, which is usually done through a proper investigation. So looking into the facts, following up on evidence, and then putting the allegations to the respondent. Now, where an employer fails to conduct an investigation or fails to conduct an investigation properly and put the allegations of misconduct to the employee, it could impact an employer's ability to successfully advance their defense and prove that they had just cause at a hearing, resulting in an employer being liable to the employee for wrongful dismissal damages, which, depending on an employee's age, years of service, position, and other various factors, could be quite significant. Or in the unionized context, it could also result in damages for lost wages and potentially reinstatement of the employee. Now, in addition to wrongful dismissal damages, if an employer fails to conduct a reasonable investigation, the employer could also be exposed to liability for aggravated damages, punitive damages, as well, for the manner in which the investigation or the dismissal occurred. So conducting a proper investigation is extremely important because it allows an employer to make decisions that they can reasonably rely upon during legal actions. A good case exemplifying this point was a decision that came out in Ontario in 2019 called Headley Citation. Citation for that case is 2019 ONSC 4496. Now, in this decision, the Ontario judge awarded damages over $170,000 to an employee of a homeless shelter that was terminated for just cause for having allegedly stolen a client's maintenance fees. A large basis of this award was based on the finding by the judge that the employer's investigation into the matter was wholly inadequate and based on false assumptions. When commenting on the investigation, the judge specifically noted that the conclusions from the investigation were based on incomplete information, and that during the investigation, the employer failed to consult with relevant witnesses and consider alternative explanations for the missing cash, and that the employer also did not look into explanations provided by the employee or take into account evidence presented by other employees. When awarding the remedy, in this case, the justice awarded the employee who had been employed in a mid-level position for 15 years, 18 months of notice. In addition, the judge also awarded the employee $75,000 because the employer failed to meet its obligations of good faith and fair dealing. And a large part of that was also based on the flawed investigation. So aside from the common law and labor context, it's also important to note that human rights jurisprudence, it is well established in human rights jurisprudence that an employer has a duty to also take reasonable steps to address allegations of discrimination and harassment in the workplace, which also include conducting a prompt, thorough, and fair investigation. And that the failure to meet this obligation could also result in significant damages being awarded. So you have the common law, you have the human rights space, and you also have occupational health and safety to consider here as well, because an employer's obligation to investigate is also codified under occupational health and safety legislation. Now, depending on which province you are in, the obligations may differ slightly. However, in general, the employer's obligation to investigate has expanded in the past several years to include protections against workplace harassment, workplace violence. The definition, which also generally includes bullying, psychological harassment, which are not necessarily tied to prohibited grounds under the human rights legislation. So under under occupational health and safety, employers do have a positive obligation in specific circumstances to investigate matters and to also prepare and implement policies on how employee complaints will be investigated, and to also conduct an investigation in specific circumstances as well. And failure to do so could potentially also result in liabilities and penalties under occupational health and safety. So it is extremely important to take investigations importantly, especially when you are potentially dealing with OH&S issues, human rights issues, as well as potentially misconduct that could potentially lead to an employee being terminated for cause. Now, turning to the second question as to when to investigate, a common question we get asked is, when should an investigation commence? Now, specifically, an employer may receive a complaint from an employee, a consumer, or a third party, or alternatively, an employer may observe concerning behavior or receive a whistleblower complaint. And then the question becomes, should this matter be investigated? Now, to determine whether an investigation is warranted will depend on the circumstances and the nature of the complaint received. Some threshold questions that employers should be asking themselves when they receive a complaint or see something concerning is potentially, if the matter complained of was proven to be true, would it breach their policies or otherwise be legally problematic or create legal liability? Alternatively, employers should also be asking themselves that if they have a legal obligation to investigate under human rights or occupational health and safety. Now, if the answer to these questions are yes, then an investigation generally should be commenced. And depending on the circumstances, what that investigation may look like may vary. And my colleague, Victoria, will momentarily expand on that. But generally speaking, if those elements are triggered, an employer will likely need to be conducting some form of investigation. Now, circumstances where investigations are most often triggered, again, would be where an employee's misconduct is so serious that, again, if true, it may result in the employee being terminated for just cause. So, for example, allegations of fraud, theft, harassment would likely all trigger the obligation to conduct some form of investigation. Also possible violations of human rights legislation. So this would include allegations of discrimination or harassment based on a person's race, religious beliefs, physical disability, or any other protected ground under human rights legislation. Or also instances of workplace harassment, violence, assault that would also potentially trigger an employer's obligation to investigate. Now, once the decision to investigate is made, then the question becomes, what should the investigation look like? Should a third party be hired? Could this be conducted internally? And what I will do now is I will pass on the presentation to my colleague, Victoria Merritt, in our BC office, to discuss key issues that should be considered when conducting an investigation.
Thanks, Roxana. As Roxana indicated, our second presenter today is Victoria Merritt. Victoria is also a member of Dentons Canada Labour and Employment Group. Victoria has diverse experience advising clients on all managing aspects with respect to employment matters, including workplace investigations. And today, Victoria is going to discuss key issues for employers to consider when conducting an investigation.
Thanks, Allison and Roxana. So I'm going to be discussing 5 key areas to consider when conducting a workplace investigation. And if I can have the next slide, please, Peggy. So one of the very first considerations is, are there any immediate risks? And this can fall within 2 broad categories. So first, health and safety. So this is going to be where you have serious allegations around sexual assault, for example, or some sort of physical altercation. You may need to take immediate steps to ensure the health and safety of employees. There's a number of different options to do this. There's a few set out on the slide here. There might be an administrative suspension pending the completion of the investigation. You may be able to reassign individuals. Remote work may be an option. I have a little proceed with caution image on this slide because one of the things to be very careful of is with respect to the respondent, particularly where allegations are really egregious. I think it's tempting to act really quickly, but it's important to recognize that respondents have a right to a full and thorough investigation, and it's a criminal law concept, but the innocent until proven guilty should also apply. So while these steps can be taken to ensure safety, it's important that they're temporary, and it's important that they are not punitive. The other category of risk might be around reporting requirements, for example, to insurers, to the RCMP. There might be board reporting requirements, or you might have internal reporting requirements. So again, this one's fairly straightforward, but it's important to take that first step to determine if there's anybody you need to be reporting the fact that there's going to be a complaint or an investigation to, and then add them to your list of people to kind of keep appraised of the status of the investigation. Next slide, please. So the second broad area to consider is going to be your legal framework. And again, this is important because it can vary considerably depending on what you're dealing with. So the very first thing to do is to look at your own policies. So a policy is only as good as its implementation. So if there are copies, blow off the dust and see, what does our bullying and harassment policy actually say we'll do if, for example, the complaint relates to bullying and harassment? Did you set out timelines? Are there particular processes that you need to follow? And depending on the type of investigation or the nature of the misconduct, there may be other policies that come into play, a code of conduct, and depending on your organization, this can be quite broad. So you want to identify those very early on so that you're able to comply with your own policies, because that's something decision makers, if they're reviewing the investigation, will be concerned with. Similarly, you of course want to be aware of the applicable legislation. Federally regulated employers will have quite different rules than provincially regulated employers in terms of some of the specifics of conducting an investigation. You also want to be aware of provisions that might apply within human rights legislation, occupational health and safety, sometimes employment standards. And then if you're dealing with investigations beyond sort of bullying, harassment, or discrimination, there may be other legislation that comes into play that you want to be cognizant of as you're preparing for your investigation. Next slide, please. So another consideration, again, fairly early on, is going to be the scope of your investigation. So this involves actually assessing the complaint to determine who's involved. What are the allegations? Are they serious? Maybe a preliminary consideration of what the complainant wants out of it. Also looking at what evidence is going to need to be gathered for witnesses. You know, are there 20 people who saw the alleged misconduct, or are there 2? Is it going to be a document intensive investigation where, for example, you have an allegation of fraud or theft? And is there any other evidence like security footage that you're going to need to gather and consider? For documents, that can be quite broad. So text messages, photographs, emails are very common to be reviewed. And this is all important because it's sort of allowing you to assess what resources are going to be needed to conduct the investigation. And that's very important for the next consideration. So if we can move over to the next slide, please. And this is where I'll spend the bulk of my time. And that's, of course, considering how you should conduct your investigation. So one of the first and sort of key considerations would be whether or not you should be conducting an internal investigation, so doing it in-house, or if you should retain an external investigator. Now, the factors to consider set out on the slide are, of course, not exhaustive, but are some of the things that you're going to want to be considering. And the first one is, of course, the nature of the complaint. As a general rule, the more serious the allegations, the more appropriate it is to involve somebody external. So allegations of fraud or, again, really serious sexual harassment or bullying. On the other hand, if you have a complaint involving sort of more minor allegations of bullying between peers, for example, you know, he calls me names, they don't respect me, those might be the sort of things that can be addressed in-house. The other consideration, of course, is what in-house expertise you have available. And that means having somebody who's properly trained in conducting workplace investigations. So understanding principles of natural justice and procedural fairness, they have the ability to make finding of facts and to resolve conflicts in the evidence, and perhaps to make credibility assessments, which are quite commonly required in workplace investigations. Somebody with good interview skills and experience in that area. They also have to be somebody who's, of course, not involved in the complaint and doesn't report to either party involved. And they also need to be available to promptly investigate. And you'll see I sort of have an asterisk next to effective use of resources. In some circumstances, it's a more effective use of resources to retain an external investigator if the issue is sort of resources around time and people as opposed to cost. It can be more effective to have an external investigator. And it's also important, and I'll talk about this more, that investigations are timely. Roxana highlighted that as well. So sometimes it's necessary to bring in outside help just to ensure that the investigation gets done within a reasonable time frame. If your HR person, for example, is very busy doing other things. The other consideration is around basically who's involved in the complaint. So as soon as you have a very senior member of the organization or somebody in human resources, or of course the person who would be conducting the investigation involved, that's where it's appropriate to retain an external investigator. Sometimes it's also just an optics issue. So for example, there's a close personal relationship between the respondent and the person who would typically conduct your investigations. You know, they might be perfectly capable and have the expertise to conduct the investigation without any issue, but the optics of that are going to look problematic from the perspective of the complainant, for example, or vice versa. If there's a relationship with the complainant, of course, that might send some red flags to the respondent about perceived bias. The other consideration is if there's any sort of particular expertise needed. For example, some external investigators will have training around conducting trauma-informed investigations, or if there's a particular human rights aspect that you want somebody a little more specialized for. If it's fraud, there's a forensic element, you may want an external investigator. Similarly, if there's a level of IT knowledge required, again, you might look for somebody who's external, who has those unique qualifications. And of course, the other factor around conducting an external investigation, which I believe David will be touching on more, is the advantage of having legal privilege over your investigation report, which can be available when you have an external investigator who is also a lawyer. Next slide, please. So once you have decided if it's internal or external, there's a few best practices that apply quite generally. And one of the first is just simply to treat complaints seriously. And this includes complaints that may seem trivial initially on review. It doesn't mean that all complaints need to be treated the same, of course. Your investigation and response should be proportional to, as we've discussed, the nature of the allegations, the type of misconduct that's been alleged at your organization. However, every complaint should be treated seriously. The second best practice is simply to have an investigation plan. This becomes less important, of course, if you've retained an external investigator, because that individual is going to be responsible for having the plan and executing that plan. If you're conducting it in-house, however, it's important to have sort of a roadmap for your investigation. This is going to include, what witnesses you're planning on interviewing, what's your process going to be for that? Are you going to do it virtually, in person? What other information do you need to gather, and how are you going to get that? And then how are you going to comply with all these other obligations that we'll talk about in the context of your investigation? Another best practice is to ensure that you're communicating carefully and consistently with the parties throughout the investigation. And when I say the parties, I'm meaning primarily the complainant and the respondent. And it can be a bit of a delicate balance to kind of maintain confidentiality and the integrity of your investigation, while also keeping the parties updated to some extent. So this starts right at the beginning of the investigation, when both the complainant and the respondent should be notified that an investigation has been started and who's doing the investigation and the process for that. It's important to be careful not to commit to unrealistic timelines or perhaps overly specific timelines, because the length of an investigation can evolve throughout the investigation. So in some cases, for example, there may be more witnesses identified once you've spoken with the complainant and the respondent. And then that's, of course, going to add a bit of time. So when you advise the complainant and the respondent, it's important to tell them about their obligations in relation to the investigation, which includes maintaining confidentiality, cooperating with you, and then, of course, very importantly, that there's no retaliation permitted for being involved in an investigation, for making a complaint, or for participating in an investigation at all. In the case of the respondent, again, they are given the opportunity to respond to the allegations, and to do that, they need to know what those allegations are. So again, this is a bit of a balancing act in terms of ensuring they have sufficient detail to provide a response, without necessarily having to particularize absolutely everything before you interview them, which can impact the evidence that they give in the interview. However, they basically have to understand sort of the case to meet, we want to use that language, or what allegations have been made. We've talked already a fair bit about conducting investigations in a timely way. And of course, what does timely mean? It comes down to one of lawyers and judges' favorite concepts, which is reasonableness. Really, it's good practice to avoid any sort of delay that doesn't have a good explanation. So you got the complaint and then it sat for 3 weeks before anything happened. Or you interviewed the complainant and then it was 4 months before the respondent was interviewed, for example. So it doesn't mean that things have to be done super quickly, because of course you're balancing this with the obligation to investigate in a way that is thorough and fair. So basically, keeping the momentum going, making sure you have timelines, and if you're working with an external investigator, making sure you're keeping updated in terms of the timelines. As I already mentioned, sometimes these can things cannot go quite the way your initial plan looked like if there's more witnesses identified, and it can take time. The more complex the investigation is in terms of the actual nature of the allegations, the more witnesses you have, 20 witnesses, that's going to take some time to set up and conduct those interviews if you in fact need to interview all those people. So again, the important thing around timeliness is just to avoid having these big gaps or delays that are going to be difficult to explain down the road. Next slide, please. So the first point on the slide is probably one of the most important, which is to be fair and impartial in conducting the investigation, and both in appearance and in actuality. So there's the saying, it's important not that justice be done, but that it's seen to be done. That's really, really important in the context of workplace investigations. So both parties need to be given a full opportunity to be heard, and the investigator has to consider all the relevant evidence. The investigator also has to remain neutral throughout the course of their investigation. And this can be challenging because, again, you're balancing being empathetic to the parties, but also staying very neutral. For example, one thing I've had to intentionally work on is cultivating a bit more of a poker face, a very expressive face. So it's pretty obvious when I'm agreeing or disagreeing with what people are saying, and both in court and in workplace investigations, I work very hard to ensure I'm remaining neutral, while of course still being engaged and empathetic with the parties you're interviewing. So when you conduct an investigation with this idea sort of front and center, it can also mean that the complainant or respondent are going to be satisfied with the process, even if they're unhappy with the result. And I would say sort of inevitably in an investigation, one party is going to be unhappy with the result because the complaint's either going to be substantiated or it's not. However, you can conduct an investigation where the party who, things didn't go the way they wanted. So either the respondent was found to have engaged in misconduct, or the complainant had their complaint not substantiated based on the standards used in the investigation. They still may feel that the process was fair, which is of course important, and that's also going to be what a decision maker is looking at. Respecting confidentiality is of course important. And again, that can be very small things like being cognizant of what you're naming your calendar invites, for example, for interviews, and ensuring things are communicated only on a need to know basis. Documenting the investigation carefully. You can conduct the most perfect investigation in the world, but you want to be able to show that it was done properly. It's also very important to document when it comes to making findings of facts, if you're conducting in-house, of course, because you're going to need to have a really good record of the evidence that you reviewed to resolve conflicts and actually make your findings. And the final point here is just to offer support to the parties. Workplace investigations are incredibly stressful for everyone involved. They're often very emotional. Respondents are often, obviously and understandably, very upset at the accusations that have been made against them. And of course, for complainants coming forward can be very scary. So offering support can look like, if you have an employee assistance program, for example, specifically reference that in your sort of initial correspondence, and make sure the parties feel like they have sort of these supports throughout for what is, like I said, a stressful process for everyone. Next slide, please. So this is sort of the key question for how you should conduct your investigation, which is, what would a decision maker think if they scrutinize the investigation at the end of the day? Were people treated fairly? Were things done, to the best of your ability and in good faith? So it's not a standard of perfection, but you certainly need to be able to show that you followed some of the things that we've talked about throughout the course of the investigation. Next slide, please. So, of course, the final consideration is what happens after you concluded your investigation and you have findings and you have an investigation report. So, of course, you need to communicate the findings to key stakeholders and to the parties. Now, we do not recommend providing a copy of the investigation report to either party. It's usually not necessary. It usually discloses way more detail than either party needs to need. So there's ideally a summary of findings that can be communicated. Similarly, key stakeholders, so reporting internally, or if you have any of those external parties involved that require an update, consider the level of information they're being provided with. And if you've had your report conducted externally, it's important to maintain privilege over that. In terms of the steps you can take, if the complaint's been substantiated, what you do is obviously very dependent on the nature of misconduct, of course. So that this can range from sort of informal mediations and an apology, workplace training. There might be a change in duties or reporting relationship. And of course, for more serious misconduct, it can result in discipline up to and including termination of employment for cause. So what you do will really be crafted based on the nature of the allegations and of course, what the findings said. Another point to consider is that you might want to take action even where a complaint's not been substantiated, simply to maintain good relationships in the workplace. So again, that can include sort of informal discussion with the parties if they're willing, setting up a communication plan going forward, even where there's not misconduct actually found. And again, it's important to remind parties after the investigation concludes that retaliation remains prohibited and to report it if it occurs. Next slide, please. As well, if you have recommendations that are made in a report, and this is often common with an external investigator, if you've asked them to make recommendations, they may make recommendations that are not practical, perhaps for you to implement, or they're not something that you can implement right away. If that's the case, that's fine, but you do want to document your reasons why in case that comes under review later. And the final point to make in terms of considerations for your investigation is to consider an investigation as sort of this broader learning opportunity. So I think it's tempting once the report's done to sort of file it all away, but it's a really great opportunity to review and update your policies and procedures. What worked? What didn't work? What felt like it really tied your hands? What slowed things down? So you can update those because, of course, ideally, your policy is a useful tool. Are there ways to improve efficiency? So if you conducted it in-house, you might say, oh, it'd be great if we had sort of template correspondence, for example, when a complaint starts in terms of what we're doing. And finally, you may want to consider if the investigation identified any broader issues within the organization that you weren't aware of, that you can sort of proactively action now rather than wait. And with that, I'll wrap up my section and turn it back to Allison to introduce our next speaker, David.
Thanks, Victoria. Our final presenter today is David Conkin. David is a member of our Denton's litigation group. However, in addition to being a commercial litigator, he has a hybrid practice where he insists and also leads internal investigations into allegations of business misconduct, such as anti-corruption or bribery. Today, David will be discussing the consequences of a flawed investigation.
Thank you, Allison, and thanks everyone for joining us today. As just said, my practice is focused less on the inter-employee misconduct and more on the financial end of things. And so that's where I'll try to speak more broadly beyond that. But so you're aware that's the perspective that I'm coming at in giving my portion of this presentation. Can we have the next slide, please? So I'm going to be talking about consequences of a flawed investigation, but also not just trying to put forward the doom and gloom, but also some considerations to be having as you are preparing for the investigation, doing the investigation, tying in very much with what Victoria was talking about. But I'll go in a bit more detail on some key topics, particularly for these types of financial investigations. One of the absolute key considerations in this is privilege. So I'll be spending some time on that. I'm going to talk about the impact of investigations on employees, employee culture, and then as well, where internal investigations fit with enforcement authorities and what their expectations are and how you can negatively impact your relations and potential punishments that may come from enforcement authorities if you do fail to take certain steps in investigation. Next slide, please. So privilege in terms of investigation, we've talked a little bit already about whether to do an internal or external investigation. And that distinction also can take into account whether you have internal counsel, lawyers who are conducting the investigation versus bringing in external legal counsel. Roxana's walked through a few of the considerations for how to make the distinction between whether to do an internal or external investigation. I'd like to focus particularly on when you want to have counsel involved. And this really, I think, is really dependent on what the subject matter of the allegation is. Think about where this investigation could end up. What if the allegation is proven to be true? Where does that put the company, and what are the implications that it could have for it? Is there going to be litigation that comes out of it by employees or potentially by contractual counterparties, where some misconduct by employees, attributed to the company can be a contractual breach? Is there a potential for negative publicity for the company? And then most critically in my world, are you going to have enforcement authorities involved, whether that's police, the RCMP, whether that's the securities regulator, an environmental regulator, where you need to be thinking about, okay, well, we've gone in and we've figured out what's happened in terms of the misconduct, and say we found something problematic. Well, if we write up a report and provide an absolute roadmap for an enforcement authority or a plaintiff in litigation, and that report and that investigation is not covered by privilege, well, you've now handed them the roadmap to establishing their claim against you, or establishing the offense that has been committed. And so that's where privilege comes in and is critical in these higher impact investigations, where it's the best tool to defend yourself against the good work that's been done in the investigation coming out and actually damaging the company later on. Next slide, please. So I will speak for just fairly briefly on the two types of privilege that are important for investigations: solicitor-client privilege and litigation privilege. Certainly a lot more could be said about these two types of privilege. We won't go into that depth in this webinar. If there are questions about privilege, happy to take those in the question portion of this session or offline as well. Solicitor-client privilege, that's the one that is most well known of that ability for clients to seek and lawyers to provide legal advice to those clients. But it has also been found to apply more broadly to investigations that lawyers are conducting, because they need to be able to ascertain what the facts are in order to be able to provide that legal advice. So a quote from a Manitoba Court of Appeal decision here. But this is really the best of the privilege on offer in terms of investigations. Of course, it is going to require the involvement of counsel. It won't protect most discussions that are not involving counsel. And something to be aware of is that there are jurisdictional differences outside of Canada on solicitor-client privilege. For instance, there's been a question about this: is there a distinction on having internal counsel do an investigation for privilege purposes? In Canada, unlikely right now, but in European jurisdictions under the civil code procedures, or as well, there's some increasing doubt in the UK whether internal counsel are viewed as sufficiently acting in a legal capacity rather than in a business capacity, that their involvement may not always attract solicitor-client privilege. And so particularly if you have a jurisdiction that is covering multiple jurisdictions, you need to be thinking about, from a privilege standpoint, what are the different what are the different laws in place here? And if you are, involved in a investigation that has, part of the misconduct may have occurred in Germany, are you opening yourself up to have your investigation discoverable by German authorities? Go to the next slide, please. Litigation privilege, its benefit is that it's much larger than solicitor-client privilege. It applies whether a lawyer is involved or not. It can, apply even to third parties where the communications that are involved there are for the purpose of litigation. But the critical part of it is that those communications, the records created around them, they must have as their dominant purpose being contemplated litigation. So this is in my view, not as friendly type of privilege, not one that I am I'm more reticent to rely on instead of solicitor-client privilege, because particularly for investigations, the starting point at which litigation is contemplated is often not right at the outset of an investigation. There simply often is not enough information for the company to be able to make determine that litigation actually is contemplated, who that might be with, and the specifics about who that would involve. And that's the same thing as well with enforcement authorities, where you have a potential regulatory or criminal offense. So that starting point is critical, because anything that is before that point at which litigation actually becomes contemplated, litigation privilege does not apply. And then if you are under an obligation, say a regulatory requirement to conduct an investigation into some type of incident that's happened, the courts have found that litigation privilege doesn't apply to your internal investigation, because you were required by statute to conduct that investigation. So clearly the dominant purpose of the investigation was to comply with your legal obligations, not to prepare for potential litigation. And then finally, with litigation privilege, it expires when that contemplated litigation is complete. And so your internal investigation can then become discoverable. There are exceptions where there's some types of follow-on litigation that it might continue through that, but it's a much less certain type of privilege, and certainly relied on in internal investigations. Where there's an opportunity to do so, you can better protect the company by using solicitor-client privilege. Go to the next slide, please. One, I think, maybe not as often thought about aspect of investigations is some of the consequences of where a faulty investigation, what those consequences have on employees. The obvious one of this is that you can end up with a wrongful dismissal suit. That, as Roxana was saying, it is the employer's obligation to be able to establish just cause in a suit. And if you have an investigation that is not follow the proper steps, not tested some of its assumptions, then your case at trial may not be as strong as you would like it to be. I've been involved on the plaintiff side for an executive where we managed to show that the company had failed to take proper steps in its investigation. It did not dig into the allegations, just took things at face value, terminated the employee, and the court refused to accept them as having kind of done their due diligence, and they failed to establish that they had any right to terminate the employee. And the egregiousness in which they had failed to treat the employee fairly resulted in a full indemnity cost award. And so that's over extensive years of litigation, that was quite a significant cost award. So doing an investigation properly can save you down the road. It can provide all that backup information, showing the due process that's been provided to an employee that will help you if you do end up in litigation. With the collection of records as part of investigation, there are always going to be privacy considerations. And as with anything, add in multiple jurisdictions and this gets more complex. You need to be very focused on what contractual rights the company has in order to gather records that may constitute personal information of employees. There are different legal regimes that apply, certainly be different between Alberta and Quebec or involving the EU, different American states, California, various different standards that, and the reasonableness and proportionality of how you are of your investigation to the need to acquire that potentially personally identifiable information is a consideration that if you don't get right, can cause you to have privacy complaints and issues down the road. We're having investigations that are timely, that are thorough, that demonstrate that a company is serious about misconduct and doing something about it. That's good for employee morale, but conversely, a company that is not showing that it cares about those things, or that it even in its investigations that it's going to treat employees fairly in how it investigates, will have an impact on morale. And from building a company compliance culture, one of the beneficial things of being viewed internally by your employees that your investigation process is rigorous and fair is that they will bring forward information on potential wrongdoing to you, which is a lot better than finding out about potential wrongdoing when the enforcement authorities come to your door with a warrant. If employees do not believe that you are serious about investigations because they've seen investigations that don't go anywhere, they'll be discouraged from bringing up these complaints internally, and you'll have the much more unfortunate process of being very reactive to an external third party rather than having the opportunity to get the first shake of it yourself. I'll move on to the next slide, please. On enforcement authorities, and again, so this anyone from RCMP to various types of regulators, their expectations for how investigations are conducted are only rising. There is, I think there's a trend now of more rigorous approach to regulate businesses, and that's flowing through right into investigations. And some ways that comes about, a good example being custody of evidence. If you have any desire to cooperate with a regulator or enforcement authority, because there are there's potential for leniency coming out of cooperating with the authority, whether that's payment of a lower fine, all the way to negotiation of a remediation agreement to avoid the stigma of criminal conviction, and also to lower financial penalties. Then you need to conduct an investigation in a way that they will essentially that they will appreciate the way that you've conducted it. It differs for different regulatory authorities. Some want to want you to do the investigation, put a bow on it, and provide all that information to them. Some want to be involved in directing how certain aspects of the investigation take place. Others are just going to do their own thing, and they want you to stay out of their way. And some areas where that applies, where you can be helpful, is thinking early on in the chain of custody of evidence. You're gathering all of this data from company servers or employee devices, and if you want to be able to provide that to an enforcement agency in a way that they can rely on, particularly where there are criminal charges potentially at issue, you need to be very clear on that chain of custody. and potentially involving, maybe not only external counsel, but a third party as well, such as an accounting firm. An area where there is significant difference between enforcement authorities is a view on trampling the scene. And this gets very much the degree of involvement or organization that they want to have with a company that's doing an investigation. The concern here is that a company, in the course of doing its internal investigation, goes in and starts interviewing employees, and it by doing so tips off the wrongdoers to the fact that they're being looked at closely. And so by the time that the enforcement authority goes around to conducting interviews, they've had an opportunity to get their stories straight, and they're just not getting the same caliber of information that they would get at first blush. It may also be that the enforcement authority isn't concerned about that, but they want to talk with the company about whether they're going to be able to get notes from an employee interview. There's a question in the chat on whether to report interviews. My position on this is that if you are trying to assert privilege over any of your investigation, that you certainly do not want to record your employee interviews. There's a very good chance that a transcript or a video or audio recording of interviews will not be covered by privilege. And even the best interviews are not fully controlled, and you don't want to lose control of what comes out of that interview. So where you have involvement with counsel, there's an art to drafting notes from an interview in order to be able to bring them within the scope of solicitor-client privilege. Now, if you are in a context, a lower risk case, you're not involving counsel, a recording can provide a very clear record of the interview. I may have some of my employment colleagues speak on that more specifically, but certainly if you were trying to assert privilege, recording an interview is a way to pull yourself out of the shield of privilege. And so just lastly on wrapping up the enforcement authority side of this, it's how you conduct your investigation in a manner that takes them into account. And this is again where you have an eye towards cooperation that will impact how likely they are to view you as having cooperated well, made their investigations easier and less costly. So it's having an eye to some of these steps as early on as document collection and throughout the course of not tipping off the potential wrongdoers that can put you in very good stead for that the end result of the investigation being potentially a finding of some wrongdoing that's attributable to the company, that can be significantly less costly. That's it for my presentation. So Allison, I will turn it back to you.
Thanks, David. So we have a number of questions in the Q&A, and so we want to thank everyone for their questions. We're going to try and get to them today, but we might not get to them all. I know we have only 5 minutes left. So can we just move to the next slide? So if we don't get them today, I just do want to let you know about the resources that Dentons has to help you. So we do provide support and advice to clients when they're conducting investigations internally. We can provide support in that process. We also provide advice and support in, okay, you've done this investigation, like what do we do now? We also can go in and conduct workplace investigation training or provide training presentations that you can in turn, present to your employees. In addition, we also conduct workplace investigations. So if you do need an external third-party investigator, that's a service that we offer. So if you do have any questions, don't hesitate to reach out to myself or anyone else on the panel. So I'm going to try and get to a couple questions, like I said today. And so one of the questions that we got was, what do you do if it's a he said, she said situation and there's conflicting stories and there's no other witnesses available? how do you conclude those and deal with them? So this is a, obviously a difficult situation when you have a he said, she said. When you're doing, this will often come down to the credibility of the witnesses. So, things to consider, internal consistency, does the person's story make sense? Does it add up? Is it believable? And the test that you're applying is the balance of probabilities in determining, whether this is believable. So, it's like 50% plus 0.1 kind of is a balance. Did the person take any contemporary notes? Did the person speak to someone? Like often someone, they don't necessarily have a witness, but they spoke to someone after the event about what happened to them. Like I said, you have to kind of assess, are they consistent? Like it often comes down to credibility. Factors that affect credibility, like are persons willing to admit facts that are not in their favor? I don't know if Roxana or Victoria want to jump in on that one.
Sorry, Allison, what was the last little piece?
Do you guys have any other comments in terms of how you assess a he said, she said issue?
Yeah, no, I think what you mentioned are all the good points that I'll generally look into. I think in addition to those points, sometimes I will ask for specific physical documentation that they may have that supports perhaps some of their statements. In addition, I think it's really looking at the statements as you set up, looking at whether or not and assessing credibility in terms of how the individual perhaps was during the investigation, how they responded to perhaps some questions. There could potentially be some telltale signs there, and really looking at and assessing the credibility of the individuals, because I think that's what ends up really coming out, and the points that you addressed also help assess the credibility of the individual. Victoria, I don't know if you have anything else to add.
No, nothing to add on that one.
One of the questions is, what if someone wants to bring a support person such as a friend or family member or even external counsel to the investigation meetings? As long as the support person is not participating and sits there quietly, is that okay? Does Roxana or Victoria want to jump in on this one, or even David?
Less common in my world.
Well, I can give some thoughts on that. So I think this is a question that's becoming more and more common. I think in the past, employers generally didn't allow a support person. I think that has changed, particularly with the notion of a trauma approach in terms of conducting investigations. And part of that often involves, making the individual comfortable. Like, is that, do they need, and that may involve a support person. Obviously, a support person can be a tricky issue. You don't want the person to be someone who's involved in the investigation, or is a potential witness, because obviously that's going to be problematic. You want to make sure that that person is actually comfortable speaking in front of the situation. Recently, I had a story told to me where the person had a support person who was their spouse. And then after the investigation meeting, they said, oh, I wasn't comfortable actually talking in front of my spouse, so I actually didn't tell the truth, and here's what my story is. So you want to make sure that the person is actually comfortable speaking with that person present. There's also issues in terms of, if it's a unionized employment, they might have a right to have unionized representation. And so you want to be making sure that you ensure that they're getting that proper representation and that you're not excluding the union. And in terms of legal counsel, again, like I think it's becoming more and more common to see legal counsel. Legal counsel can be a good thing or a bad thing. Sometimes you get legal counsel who kind of misunderstand what a workplace investigation is. They think this is more of a hearing. They want to make submissions as opposed to sit back. In other cases, legal counsel can be helpful in the sense that they can take their client aside and say, okay, you can answer that and so forth. At the end of the day, I think if the person is insistent on having a support, I think, I don't think you'd not want to interview them. I don't think that would be a hard line that you'd want to take. I think that, particularly in certain circumstances, it might be very reasonable for them to have a support person. But with that support person, depending, you just want to set some ground rules that, they're here to support, not make submissions. In some situations, you can have the parties sign confidentiality agreements if it's very, serious or sensitive. That is potentially an option. I don't know if anyone else wants to add anything. There was a question here about claiming, I think we have time for maybe one last question. I'm just going to see if there's ones where there was some multiple. And there was a question here about what if the person is already on probation? Does that change how you conduct an investigation? Victoria, did you want to comment on that?
They're already on probation. I mean, not significantly, because they're still entitled to have it treated sort of as fresh allegations, essentially. So I think you would want to be just as careful, because again, it's more to do with the procedural fairness aspect than sort of the person's track record. I'd put it that way. Although, yeah, I don't know, Allison, if you have anything to add, but I don't think that would materially change how I'd approach an investigation.
No, I agree with Victoria, because like you said, out of procedural fairness, you have to assess this, investigation, new. And so it's not going to change how you follow the process in the course of the investigation. I don't know if the probation might factor into the investigation if it's on the same grounds, but it doesn't affect how you should go about conducting the investigation. It should be the same process. So we're actually over time now. Unfortunately, we didn't get to all your questions. If you do have any, further questions, please feel free to reach out, or if we didn't get to your question today, please feel free to reach out. I want to thank everyone again for attending, and we hope we see you soon.